This is the appointed time, and this is the meeting of the Subcommittee on Inland Revenue Amendment of Schedule 17E Notice 2016. Election of Chairman, any nomination? Kenneth Leung, do you accept the nomination? Yes. Okay, so I second that. No other nomination, so you are returned as Chairman. That's it.
好，主席冇意見。得，我知啦。
Chairman, no comment. Is there a need to elect the Vice Chairman? No? So let's invite the administration in. You asked whether we have comments, so I just answered no comment.
得 ，OK， 得。各位官員，大家好，大家好。咁我哋今日
We have with us today from the Financial Services and the Treasury Bureau, Inland Revenue Department, and the Department of Justice, the team from the administration. I won't go through the attendance lists one by one. We are here to discuss the amendment of Schedule 17E. If there is no objection from members, may I suggest that we use the marked up copy provided by the administration, or perhaps I should ask Mr. Lai to walk us through the amendment first, and then we'll start the clause-by-clause examination. Thank you, Chairman. I understand that when we scrutinized the bill in the first half of this year, Dr. Leung, Chairman, you were also a member of the Bills Committee, so I believe you are very familiar with the bill itself as well as the amendment on this occasion. Mr. Wu Chi-wai, it seems last time was not a member of the Bills Committee, so perhaps I should spend a little bit of time to brief members on our work. In fact, the schedule is very simple. The Secretary for Financial Services and the Treasury is going to amend Schedule 17E in accordance with the Inland Revenue Ordinance, IRO, and as set out in the paper, the amendment involves two changes. That is, we will add Japan and the United Kingdom in the reporting jurisdictions, whereas for participating jurisdictions, we have a list of 100 jurisdictions which support the OECD in their work of automatic exchange of financial account information in tax matters. So if 17E's amendment is passed, financial institutions in Hong Kong can identify the tax residents based on the financial accounts held, and then in 2017, the FIs may then collect financial account information of these tax residents in Japan and the United Kingdom for submission to the IRD, and the IRD can then, in September 2018 or before that, carried out exchange of financial account information with the two partners. We are adding two jurisdictions to Schedule 7E as reportable jurisdictions, and they are Japan and UK. Some background information, as members may know, in terms of combating cross-border tax evasion and protecting public coffers, many jurisdictions have introduced new measures, and at the end of 2014, AEOI, Automatic Exchange of Financial Account Information in Tax Matters, was introduced. And 101 jurisdictions have signed up for this global initiatives. Hong Kong is an international city. In September 2014, we also announced support for AEOI. And then in the middle of 2015, we conducted local consultation. We consulted the financial services industry and relevant stakeholders on our legislative proposal contained in a bill. And then in January this year, we tabled into the Council the bill for scrutiny. And I'm grateful to the Bills Committee's effort, including the Chairman, Dr. Leung's effort, in examining the bill, which was passed in June this year. Now, for financial institutions such as banks, security firms, insurance companies, trust companies, under the new arrangement, in accordance with the common reporting standards, they're required to identify the tax residents of the reportable jurisdictions, followed by due diligence procedures to verify the information provided by customers. And we also have exemption arrangements, for example, for government organizations or statutory bodies such as the Monetary Authority or low-risk FIs, or for, say, life insurance policies. These institutions and policies will be exempted under the new arrangement. The information will be collected for submission to the IRD, and the IRD will then exchange the information with the partners. What are the partners? At the Bills Committee, we explained our justifications, and that is they should be CDTA partners or jurisdictions that have entered into CDTAs with Hong Kong, or TIEAs. We have 35 jurisdictions which have signed CDTAs with Hong Kong, and 7 jurisdictions which have signed TIEA with Hong Kong. So altogether, we have 42 jurisdictions which believe could be partners in the effort of exchanging information. And yet this will not be done automatically. In accordance with the OECD's requirement, the tax authority will need to further sign a CAA, a competent authority agreement, with the relevant tax authorities or monetary authorities of the jurisdictions concerned to implement the specific arrangement on exchange of tax information and protection of data privacy and confidentiality of tax resident information. The bill was passed in June 2016, and then we have followed up on the matter along with colleagues from the IRD. We have a AEOI website set up by the IRD. Report templates and an electronic platform of the AEOI is being constructed, and the FSTB understands that this may be new to clients of financial institutions. So we're going to produce APIs so as to enhance the public's awareness of the AEOI, which will facilitate our work in following up with the FIs. As a matter of follow-up, between July and September, the IRD got in touch with 10 jurisdictions which have entered into the either the CDTA or TIEAs with us to see if we could sign the CAAs with them. And so far, we have confirmed the CAAs signing with Japan and the United Kingdom. And that is why in this exercise, we are going to include these 2 jurisdictions in 17E. As for other jurisdictions, we are working full steam in order to honor our undertaking with the Legislative Council. We'd like to take a progressive approach by starting with fewer jurisdictions so that they can adjust themselves to the new arrangements. We have over 30 CDTA or TIA partners, which would be signing CAAs with us as well. In the paper, we also mentioned another point. We've only begun our work, but it seems that next year we'll need to speed up quite substantially, because we noticed that as far as the international standard is concerned, the AEOI requirements are getting more and more stringent, as mentioned in paragraph 15. The G20 held a meeting this year and endorsed the OECD's criteria, the proposed criteria. There are 3 of them for identifying non-cooperative tax jurisdictions, that is, whether they support the AEOI. And of the 3 criteria, we are able to meet 1 criterion, and we at present fail to meet another criterion. We have a good record. We believe that we should be able to meet the first requirement. As for the second requirement, the multilateral convention on mutual administrative assistance in tax matters, we prefer to sign bilateral agreements instead, so that we sign and negotiate with each of our partners. And it is possible that will be regarded as not having met the criterion. So the third criterion would be the most important, that is whether we can implement AEOI. In terms of a timetable, the importance lies in the fact that whether G20 would consider Hong Kong as a non-cooperative tax jurisdiction. So we really need to work hard. And in 15B of the paper, apart from the OECD, the European Union also kicks off their work. They're concerned whether they will get the support of all jurisdictions, and they are developing the first common list of non-cooperative tax jurisdictions. Depending on whether the requirements on tax transparency are met, some jurisdictions may be put on this blacklist called non-cooperative tax jurisdictions, and then the sanctioning may occur. So we should avoid that at all costs, and we should therefore expeditiously negotiate with our partners and sign the CAAs as soon as possible, so that by next year more jurisdictions can be included in Schedule 17E, so as to account to the OECD and the European Union in terms of our full commitment. So perhaps I'll stop here. I'll see if members have questions. We'll be happy to take your questions. Mr. Lai, thank you. Any supplement from the IRD? No? All right. We don't have many members here, so I won't impose a speaking time limit. We have Mr. Wu Chi-wai and Mr. James To. Let's start with Mr. Wu Chi-wai. A simple question. You have 100 or so jurisdictions which have signed up for the AEOI, and some other jurisdictions which have not joined. Say, for example, for Southeast Asia and the United States, these jurisdictions are not on the list. I want to know whether the bilateral tax agreements would be affected. We'll take the question, Mr. Chiu. For jurisdictions that have signed up for the AEOI, there are 101 of them as of the 31st of October. These 101 jurisdictions are, in short, major jurisdictions, large economies. Some jurisdictions are not included. For example, Syria. is having a war, and it's not included. Some small African jurisdictions are not on the list either. I asked why Thailand is not on the list. Well, let's talk about the United States. The United States has this FATCA, this act. So Hong Kong already have the exchange of financial information arrangement with the United States. They have their own system.
So there is already a system between us and the USA. As for Thailand, our latest information shows that they're going to participate. It's only that they were missing for the October 31st event, but for the whole exercise, they're going to participate. And so all economically substantial countries will eventually participate. Mr. James Toh, indeed, I've been following up on this, but these are my questions. I can see here that for part 1, you propose that UK and Japan should be added. As for part 2, apart from Hong Kong, there are about 100 countries that will participate or will be featured. I'd like to know what's the difference between part 1 and part 2. Now for Schedule 1, these are the declared tax jurisdictions or reporting jurisdictions. And so for Schedule 1 countries, FIs will have to collect tax information for a financial year or accounting year, and to exchange such information with countries that already set up CAA or have entered into CAA. So these countries are all in Schedule 1. As for Schedule 2, Mr. James Toh's understanding is perfectly correct. All over the world, there are 101 countries that are committed to observing the AEOI under OECD. And so Hong Kong is to put the other 100 countries into Schedule 2. And our objective is to put all Schedule 2 countries, especially countries that have entered tax exchange information agreement with us, to eventually join Schedule 1 so that we can exchange information with them. The FIs can exchange information with them. So what's the legal implications of Schedule 2 or of having a Schedule 2? Mr. Lai, for Schedule 2, it is for 100 participating jurisdictions, and on page 3 of our paper, it is mentioned that OECD allows countries to follow one of the 3 routes to be committed to that program. We feel that if we can include as many countries as possible, then when FIs have to carry out compliance work, their difficulties will be reduced, and that's why we have resorted to this approach. So, are you trying to say that for the 100 Schedule 2 countries, are there any things between us and those countries that we have to require them to do or they have to require us to do? Indeed, this is a very technical point, and let me step in. There are 100 countries in 17E Schedule 2. Now, indeed, the number is quite large. And what's the advantage of so doing? Because it would really reduce the procedural workload for declaring FIs. How is that? According to OECD's requirement or the proposed legislation, if the account holder or passive NFE meaning that this is a company that has not any substantial business, but its main purpose is to hold certain financial assets, and that's its own sole purpose. And if it's being managed by a professional license holder, then the FI will have to look through the passive NEA to find out who is really the real natural person that is owning this company. Now, if we were to put 100 countries into Schedule 2, then our procedural workload in the look-through procedure will be reduced. Okay, so we place 100 countries into our Schedule 2. Our banks, as a result, do not have to do the look-through work. In a paper, it is referred to as look-through. So I'm trying to say that, say, country A is among the 100 countries, and country A tax nationals, say, have set up a passive NEA or NFA in Hong Kong. So the banks from these 100 countries, therefore, do not have to look through this passive NFA to find out the natural controlling person behind the company. Of course, it doesn't mean that your work actually stops there. Now, with the countries being placed in Schedule 2, you really have to set up a information exchange mechanism with them. So you're saying that progressively, Schedule 2 countries will migrate to Schedule 1. Once we reach an agreement with a particular country in Schedule 2, then it will be migrated to Schedule 1. The next immediate targets would be UK and Japan, according to your ordinance. So the international norm requires us to gradually migrate Schedule 2 countries into Schedule 1 upon the completion of a signed agreement. And so you are aiming to put UK and Japan from Schedule 2 into Schedule 1 as your next targets, right? Yes. Chairman, I would like to go on. I'd like to know, why did you pick Japan and UK? When we were talking to LegCo about the proposed bill, we already briefed you that there are 35 countries with which we have already entered into comprehensive avoidance of a double tax system, plus 7 countries where we have entered a tax information exchange agreement with. And so altogether there are 42 such countries. And between July and September, the RRD has contacted 10 countries out of the 42 to begin negotiation on the CAA, because we have to complete negotiation on CAA before we can place them into Schedule 1. And at this point in time, there are 2 countries that already concluded CAA with us, and that's why they're ready to be included in Schedule 1. So as more countries have concluded CAA with us, then those countries will gradually be migrated to Schedule 1. And so we will go back to LegCo to gradually complete the formalities to have Schedule 2 countries that have signed agreements with us to put them into Schedule 1. So Mr. Cho is asking whether there are any countries that are really anxious to enter into agreement with us. As of now, of the 42 tax jurisdictions that we have already had an agreement with, the RRD actually has already written to all of them and invite them to start negotiation with us on CAA and invite them to join our Schedule 1. Actually, the negotiation is quite straightforward. because the CAA is actually not a document that is devised by us, but is actually borrowed from OECD's format. So the negotiation is straightforward. If a country is really anxious to get information of our own tax nationals, then they would be really willing to complete negotiation with us so that they can really have access to our tax nationals' information. And in return, we can also have access to their tax nationals' information. Mr. Yu, I'm sorry I was late, and so I might have missed your explanation. I think there is a very important phrase, look through. I'd like to know what kind of implication it will have on Hong Kong's taxpayers. Let me put it this way. The look-through process actually has no impact on Hong Kong's taxpayers because the automatic exchange mechanism is to exchange information on foreign nationals' financial activities in Hong Kong. So we have to look at whether a particular trust is actually benefiting a foreign nationals. And so this is what we mean by look-through when we try to study the case and to see whether any foreign nationals are having benefits through a trust in Hong Kong. Is there any reciprocity here? So under the two already completed CAA, UK and Japan, UK and Japan will have to hand over tax nationals of Hong Kong in their jurisdictions to Hong Kong. And Hong Kong will also have to do the same for these two countries.
Mr. Can you be more specific, say what category of residents will be affected by this arrangement and what would the impact be? Well, to use Hong Kong as an example, if you are a tax resident of another jurisdiction having an account in Hong Kong, then the account information will have to be handed over to the other jurisdiction. Let's say if I am 100% tax resident of Hong Kong, then my tax information will not be passed on to another jurisdiction. Well, I won't say that nothing will be done. I think Secretary should explain because an agreement should be signed with the bank to allow my information to be handed over to the tax authority of the jurisdiction. It will not be done automatically. Well, let me supplement. Under the AEOI framework, the bank will need to collect two pieces of information. And this arrangement is new. First is tax residency. Second is the TIN, taxpayer identification number. And if the bank finds that you are a tax resident of another jurisdiction, then your information will be passed on to the tax authority of another jurisdiction. So the banks will require the client to sign an agreement allowing banks to give out information to the jurisdictions. For for new account holders, this requirement will be imposed, whereas for existing account holders, to use the technical term, a computer search will be done to identify and flag possible tax residents. Any other questions from members? No, not from Mr. Wong. I have a number of questions. First, Schedule 17E Part 2, there are jurisdictions. So you need to make a change, even if we are not making any change when the OECD does so. So wouldn't it be cumbersome to go through electrical again. Can you explain the mechanism to me? I think your understanding is correct. For participating jurisdictions under AEOI, if the list continues to expand, and under the principle of and if we continue to be a participating jurisdiction, then we may add to the list. But we'll only update Part 2 when we are required to update Part 1 of Schedule 17.2. And in fact, for the past 6 months, there hasn't been any change in terms of the participating jurisdictions. Well, but like the member just mentioned, perhaps Thailand will participate in this initiative soon. Any other questions? Then do members think that a public hearing should be held? Should we invite deputations? No? And I think we can just do the minimum to put it on our website. I don't think we need to invite deputations. Any other views? No? So if there are no other questions from members, I'll now invite the administration to help us scrutinize the clauses under Schedule 17E. Chairman, perhaps let me say something about the notice. The notice mentions that it will take effect on the 31st of December 2016. And the relevant amendment is in Clause 3. Clause 3 states the addition of two jurisdictions, Japan and the United Kingdom, and the commencement of reporting is in 2018. And that is in relation to the financial institution account information in 2017. And then in Part 2 of the schedule, the 100 jurisdictions will be added, as mentioned by Mr. Lai just now. Unless expressly required, we're not going to read out the list. And that's it. We have 101 jurisdictions in Part 2 for Cayman, British Virgin Islands. For jurisdictions like these, would the Hong Kong SAR take the initiative to ask for exchange of tax information with these so-called tax havens? Because according to the Panama Papers, many Hong Kong residents could be involved in some tax avoidance arrangements. And we're also economic partners of jurisdictions like Japan and the United Kingdom. But apart from these economic partners, what is the position of our government in terms of automatic exchange of tax information with tax havens? Chairman, when we implement the AEOI, as explained just now, there should be a basis of an agreement signed between Hong Kong and that partner. It could be a comprehensive avoidance of double taxation, CDTA, or the TIEA, tax information exchange agreement. And under the framework of these agreements, we then have a bilateral negotiation with the partners concerned to sign the CAA before information is actually exchanged. So the premise is that there should be a taxation agreement or exchange agreement. As far as the work of the IRD is concerned, at present, we'll go ahead with the more important trading partners of Hong Kong, or jurisdictions with more investments in Hong Kong. And this is we will spend more resources to negotiate with these partners first. So far, we are not going to proactively implement AEOI with the tax havens to have the full-fledged TIEA? Because as I understand, perhaps you could give it a thought instead of a comprehensive exchange of tax information. Have you explored the idea of exchange of information with these jurisdictions? I'll try to take your question, Chairman. I think from a technical perspective, Chairman's suggestion is feasible. In fact, some jurisdictions have chosen not to sign the comprehensive tax exchange agreement with the say BVI, but some other kinds of exchange of information agreement, and this is usually done with the so-called traditional tax havens. And I think the ILD will give advice to the Bureau to see which is the most appropriate approach. Mr. Lai, I think in the coming 1 or 2 years, we will focus our resources on, jurisdictions in Europe where we wish to exchange tax information with. We need to sign the CAA first, and the negotiation takes time. At present, we have over 40 partners under the 2 agreement frameworks, and we wish to sign the CAAs with the 40-odd partners first, for them to be put under 17E first, so that in terms of our tax transparency, from the EU's perspective and from the OECD's perspective, they would not regard it as non-cooperative. So exchanging tax information with which jurisdiction and how Hong Kong can maximize the benefits, it can be done at a later stage. Any other questions? No, Mr. Wong? Then let me ask another question. In Part 1, in the footnote, there is this definition of a reporting year. I understand that different jurisdictions have different definitions for the reporting year. So can you explain to us what it means? Chairman, you just now referred to the reporting year. Yes, under Part 1, note the reporting year for reportable jurisdiction is the year beginning from. I want to know whether this will appear in Schedule 17E, because this appears in the marked up copy. Now, this refers to a reportable jurisdiction that is in 2018. We're going to exchange tax information with the 2 jurisdictions, and the tax information will be one of 2017. I want to know whether the footnote will appear in Schedule 17E. Well, the answer could be yes, because within 2018, we will be required to submit tax information of 2017 to UK and Japan. Well, Chairman, let me try to take your question. For Japan and UK, they're now put under Part 1 of the schedule, and then once the schedule is passed, financial institutions will be required to collect information of tax residents of these 2 jurisdictions starting from January 2017, and then in January 2018, the notice will be given to the FIs, so that in 5 months they will need to submit the information relating to tax residents of Japan and UK by May or June. And the tax authorities, after receiving the information, should by August or December exchange information with the tax authorities of Japan and UK, and this will be an annual exercise, and the reporting year will be a full year. once the schedule is passed, it will take effect on the 31st of December. So the first reporting year should be from the 1st of 2017 and last for the whole year. In future, what will the arrangements be? Well, each jurisdiction has a different reporting date, because if that's the case for Japan and UK, and that the cutoff date is in September, what about the other 30 jurisdictions? Which month or which year should tax information for running from a period of when to when be submitted? Let's say when 2017 ends in 9 months' time, the tax information will have to be submitted to the tax authorities. Well, but that means your workload will be so overwhelming. You won't be able to catch your breath. Well, it could be the case, but then everything is computerized. And also for the OECD, they have a common transition system. This is a platform adopted worldwide for exchange of information. And they have a specified format. They have a specified data format, which is schema. So after after collecting the information, the tax authority will just need to sort the data before exchanging information with the tax authority. I hope that the work will be smooth in future. We will allocate resources depending on the circumstances.
Just now you mentioned the system. So will you design your own system, or are you going to put it to tender? There are two parts to the system. For the international part, the OECD part, or common transaction, that particular platform is now being developed in France. Of course, Hong Kong will have to make a certain contribution to its development. As for the local part of the system, because there must be a platform between local reporting FIs with tax authority, and so the local part to the system is being developed locally, and it will be subject to insourcing as well as tendering. If necessary, we can give you written information, because work has already begun on this. Right, any other questions? Mr. Wong, very straightforward one. Okay, I'd like to talk about the timeline for the notice. Today is the 15th. If we want to submit this subcommittee's report to HC, then the fastest date would be this Friday. Because the notice is supposed to commence on the last day of this year, and the scrutiny deadline is November 31st, and the motion covering the amended legislation will have to be subject to a notification 5 days before the deadline of scrutiny. Probably we won't be able to beat that date and make that timeline. So I would like members to note that I propose that the scrutiny period be extended. I propose that the scrutiny period be extended to 2017 January 11th. Then the deadline for putting in a notice for moving the subsidiary legislation would be January 4th, 2017, which means that the date for this subcommittee to make a report to HC would be December 16th, 2016. Any questions with this timeline? With this new proposed timeline? Legal advisor, I almost forgot to ask you whether there are any legal points you would like to bring up. We have looked through this proposed amendment, and we have not discovered any drafting or legal problems with it. My feeling is that we won't need another meeting. So in the meantime, let's wait for written information from Mr. Chiu explaining to us the technical point about the development of the platform for operating the system. Any other business? No? So we have completed our scrutiny, and I think we have covered Schedule 17E, Part 1 and Part 2, and if there is no other business, then I declare the meeting adjourned. Thank you.